Director Lepore, I believe you're up.
Thank you, Mr. Chairman. As I listened to Boulder County and 8 North present, I was having flashbacks to the governor's task force, because these issues of which goes first, county approval, local government approval of locations, or hard defined locations and Form 2A approvals, was really one of the central issues taken up by the task force. The resolution of that at the task force was the different notice period and earlier engagement with local government by operators mandated in rule for large urban mitigation area facilities, which we are not in today, but the issues remain. One of the extraordinary things about Extraction in Broomfield was that Extraction agreed to go to Broomfield first and work through the process with them. We still don't have Form 2As for those locations. There are a variety of reasons why Extraction / 8 North did so with Broomfield and did not do so, chose to file these spacing applications first with the commission. The issue remains. The race to the permit issue, we've talked to you for months now, just about a year. This is the 11th month. And it comes up in a variety of contexts. You had public comment from Ed Engvey, the operator of Renegade, this morning about that, and a proposal that perhaps there should be a fee attached to applications as one kind of constraining factor on the race to the permits. The race to the permit, the race to space these lands continues to be a challenge. The other challenge for the operators in particular are surface locations. I think if you polled operators, they would tell you that securing surface locations is probably the most challenging issue facing them. Certainly one of the very most challenging issues facing them. And it can be. I have to give credence to what you heard from 8 North, that if they disclose locations, they're basically inviting competition for leasing that land and so forth. So complicated. Where that all takes me, in my mind, is greater engagement by this commission on comprehensive planning. We have the very first comprehensive drilling plan in the door on the Front Range, modern horizontal development by Crestone Peak. There have been a lot of bumps in that road. The rules aren't super clear, procedures aren't there. We've quite literally made them up as we've gone along. It's been better than I think it would be doing individual spacing units and random Form 2s and 2As. There's some work to go. As you can see from the maps that Boulder County provided, the Extraction lands are abutting the Crestone Peak lands. The fractionated mineral ownership that is a fact of life in Colorado in the DJ Basin, where Extraction has this parcel, somebody else has this parcel, somebody else has that parcel, lend to this complexity. I just want to invite you all to think, how do we get our arms around this? There's some rulemaking, 508 rulemaking, not so hard to do. Commissioner Boygan, Commissioner Hawkins really addressed it, I think. We know there are surface impacts at some level of intensity of development, not necessarily a density per square mile or quarter section, but intensity of development. And it is different for horizontal development. And you all can make a rule that changes that. It makes it clearer what we're doing with horizontal development. There's a rule on the books for geographic area plans. It is as vague as comprehensive drilling plans are. There is not procedures there. But I want to ask you to think about that and how the commission might use that tool. These issues are not going to go away. I'm convinced of that. I appreciate the engagement that we've had with Crestone Peak, with Boulder County. I think extraction in 8 North, I'll just say extraction in Broomfield, raised the bar really in their willingness to engage with the local government and to change things. We don't, you know, purely from the staff's point of view, we may or may not agree with the changes that were ultimately wrought by that. But the fact that they have an agreement with the local government, you have to honor that at some level. So there you go. I'm not offering any solutions. They're not silver bullets in any of this. You all, I think, know that. I certainly feel that way. But I think there are some tools we should look at and explore and engage with the regulated community and other very closely affected stakeholders on what can be done there.
Mr. Chair, may I ask one question of the director?
Yes, Commissioner Overturf.
Would it be valuable to solicit comments from interested stakeholders about alternatives to the current first to file approach that we utilize? It seems as though we have been implored to think about it, but I know, speaking personally, I don't have a good understanding about the universe of alternatives that are out there, and I would be very curious to hear from interested parties about better ways to do it. So could we do that as sort of a prelude to perhaps a rulemaking future down the road?
Thank you, Commissioner Overturf. Sure. We have engaged a couple of different times with the regulated community in particular about, you know, the same sort of criteria that I presented in January, and I recirculated that PowerPoint earlier or more recently for the benefit of the newer commissioners. I don't think criteria are hard to identify that, you know, we might apply. And to be blunt, I've told staff to start applying them and we'll justify them later. But when we reached out to the regulated community, we get a lot of different opinions, and some people representing this cluster of operators and some representing this cluster of operators, and really nothing has landed on our desk. But I'll do that again and ask stakeholders beyond the regulated community for their input as well.
And I guess, may I?
Yes, Commissioner.
I also wonder if there isn't value in having a, I know you have implored us to think about it, but there's also value in saying we're going to do something and we're going to do something by this date, or we want to sort of have a process by which we're going to consider alternatives. And so I wonder if there isn't value in putting up a bit more structure to our solicitation from a variety of stakeholders, not just the regulated community, because I think what I'm hearing you say is that you would like this commission to undertake a rulemaking. And so maybe I'm getting that wrong. So, so if we could receive more sort of formalized comments in order to inform whatever we think that should be down the road.
I think that's useful. I think you're sort of, well, one thing, potentially extending this hearing at a lengthy period while we have a lot of discussion about that, but this may take part of another rulemaking around what we do with respect to 508, what we do with respect to spacing applications, force pooling. These are issues that we've sort of wrestled with for years on the commission, and how we may address some of that. And I think particularly even 508, and hearing that is that, it doesn't contemplate a fairly lengthy process now where we drill all of our wells in a section off of 1 or 2 pads. So it means that the rig sits there for a long period of time. So we don't have nearly the surface impact that we used to have. Because now, you have much less of a surface impact. It's much more concentrated. So I think that those are all very good comments. I'm just not sure how long a time you want to take discussing that today.
My intent is not to discuss them today here right now.
Okay.
My intent is merely to respond to what the director put forward and to say, like, I hear you that you want us to think about it, and I would like some more direction about what I should be thinking about and what our next steps and
I'll
actions are.
undertake to have a discussion with the director about how we might proceed. And we'll come back to the commission and with that.
Thank you, Mr. Chairman.
Shall we move on? Are we on to consent agenda? Well, we do want to hear, I believe there's Courtney Shepard. Are you here? Would you like to speak? I think that we're just going to brief. You said you'd ask for a couple of minutes, Ms. Prine. So, okay.
Okay. Good afternoon. My name is Courtney Shepard. I'm an attorney with Burns Figa and Well, PC. I have two applications that should have been on the consent agenda today, but were not due to time constraints. Verdad Resources LLC, which had docket number 171200842. That's an uncontested spacing application. And PDC Energy Inc. had docket number 171200776, which was an application to add additional parties to a previously approved order for involuntary pooling. So I'm not here to necessarily ask for those to be on the special consent agenda. I just would like to raise a concern about adding additional applications to the consent agenda at the last minute. The documents for these applications were filed on time. As I said, they're uncontested. I know that the hearings officers have an immense workload, and I'm not faulting them in the slightest. I know that they're trying their best to try to get all the applications done on time. I just think that the commission is setting a precedent that they may regret by adding additional applications at the last minute, and I'd like you to either reconsider or consider what sort of consequences that may have in the future. I'm happy to come before you and ask for my applications to be considered during the public comment period, but it seems like you already have enough to listen to during that point in time of the hearing. So thank you for your consideration. I just wanted to bring this to your attention.
Thanks, Ms. Shepard. I appreciate that. I think briefly, my understanding on the ones that we did add to the agenda, that they all had some fairly serious time horizons. And so I think, yes, we are taking a risk by doing that. But I also think we're trying to accommodate that if we can. And should that happen again, we'll always take that into consideration. It doesn't necessarily mean that every time we're going to do that.
And I would just like to add that all of my clients have drilling plans, drilling obligations, economic considerations. So I think that applies to all parties.
Fair enough. I think that we'll listen to anything that comes forward if it's a case where there is a, where it appears that, I think there were a couple of cases here where someone had a rig on location, and which I think was certainly.
This goes back to me even to the special meeting that we had to have last month to make up for consent agenda items. And so I would like to know what to expect kind of going forward. Is this sort of a regular thing to sort of miss things and then add them on, or will there be extenuating circumstances that will be considered? Or as in the past, can we just expect that what's on the agenda is on the agenda and we continue to the next meeting than those that aren't on the agenda?
I think it would be, I'll ask the staff, but my preference would be as we stick to the agenda. But I would ask for staff comments.
But we changed it.
In general, that we stick to the agenda, but go ahead.
Mr. Chairman, if you'd like, Jim Rouse would spend just a few minutes to tell the commission a little bit of the process, why even if operators agree at the last minute that they're not going to protest or the protests are resolved, there's still a process that takes some time. And I mean, Mr. Rouse can explain that better than I can.
Certainly, thank you.
Mr. Chairman, Jim Rouse, hearing officer, now hearing supervisor. So basically, what is driving our problem at this time is the volume of cases and the lack of hearing officers, and the amount of contested cases that we have. And I believe what has happened with these particular 2 cases that Ms. Shepard raised was the hearing officer just ran out of time to do them because she was dealing with a multitude of contested cases and everything that goes into that, the orders, the pre-hearing conferences, the final recommendations, and that sort of thing. And then they settle at the last minute, and the time has been spent on matters that settle. And when they settle on Friday or something, we may or may not have time to get an uncontested order ready and on the agenda. Ideally, we would have everything ready to go and out to the commissioners 10 days before the hearing. And try as we might, that is just not happening because of the volume. We just can't get to it. I don't know what else to say. We're working on it. I am optimistic that we're going to get another body or 2 in here to help us. And I am also optimistic that we've got a couple extra weeks between the December hearing and the January hearing, and hopefully we can catch up a bit. So with that, I don't know what else to say about it.
Commissioner Walk.
Thank you, Mr. Chair. Mr. Rouse, do you think these requests, such as we heard during public comment and just now today, could come from you or from staff rather than from the attorneys, so that we know that the appropriate amount of diligence has occurred in order for us to consider them as part of the consent agenda?
Well, I mean, as if you want us to keep working right up until the last minute and not push them out on the portfolio, we can certainly do that and then bring it to your attention. That is something that can be done. It's also helpful if council lets us know as soon as possible that certain items have priority over other items. If there's a rig on location, it's nice to know that before 5 o'clock Friday night before the hearing.
So first, Commissioner Walk, I think it's only the commissioner's duty to work on the weekends, not the staff.
I understand.
So I guess where I would leave it is that if there are items that are sort of last minute that want to get added in the public comment period, I'd prefer we did not do that. We did make an exception today because of the way it came forward, and it sounded like there were some rigs on location. But I don't know where you are, but my preference would be is that, there's some folks on staff that have had to work today to get those items ready to be approved. So you tell me.
Well, again, I raise it if okay to have a conversation. I raise it because I rely quite heavily on staff and staff diligence and staff recommendations. In spite of all the work that we put in over the weekend, I know there's a lot more work that occurs at the staff level, and it just feels a little rushed, or it feels a little bit outside of sort of that process where staff has prepared that. And so what I'm hearing Mr. Rouse say is if it's not coming through staff because they haven't had time or it just, last minute decisions were made, then it's probably okay for us to wait until the next particular meeting.
Is that what you said? I heard something quite similar to that, I personally do not want you working up until the last minute to try and squeeze a few more things in. So do we say that our policy will be that if it doesn't get on the consent agenda by the time that you're ready to close it out, it doesn't happen?
Well, the hearing officers need to do the final draft orders to get it on consent agenda. And then that needs to go to the hearings assistant, who needs to put them on the website and get them pushed out and all that sort of thing. So this time we had a hard stop at noon this past Friday, which is really, really late from everybody's perspective, but that's what we did. And the stuff that didn't get done by then should have been continued by hearing officers just unilaterally, and it is what it is. The thing that is not helpful is to have a special hearing in the middle, because we've got to do all the hearing things to get ready for a special hearing, which in fact makes, instead of 8 hearings, 9 or 10 or however many, which is just even more work than continuing it to the next time. And like I say, if we know ahead of time that certain matters absolutely can't be continued, we need to know that in order to make sure those get done.
Okay, Commissioner Holton?
I'm inclined just to follow staff recommendations. If they want it continued, then we should do it. If they want it on here, we should do that.
Okay,
But let staff decide.
all right.
May I,
So,
Mr. Chair?
yes, Commissioner.
I
Holton.
strongly agree with that, and I don't feel that it's fair to be making decisions on things that we haven't had an opportunity to read. I would also just make the very modest suggestion that I don't know if we typically include a settlement deadline in our pre-hearing orders, but I think that might be something worth looking into about establishing a deadline by which parties are required to notify the commission that they've reached a settlement that is before Friday, and hopefully a week or a week and a half before. I think that might ease some of the pressure on our hearings officers.
Well, I appreciate that suggestion. I don't know how workable it is because we don't control the parties, and there's a long tradition of cases of all kinds settling on the courthouse steps. But in a litigation,
Move the steps to them.
yeah, in the litigation context, the judge doesn't have to have an order ready, that particular day or the next day for a commission to consider. So it is a little different situation. And I think if the parties need to understand, if they settle it at the last minute, they run the risk of being continued while we get it done.
I will say that as an attorney who practices administrative law, I regularly am bound by settlement deadlines. So I think
Okay.
that would be completely appropriate if you thought it made sense.
I'm perfectly willing to look at that.
So
I
have
go ahead,
a
Commissioner.
recommendation. What's the recommendation?
So and the only thing that I'm concerned about is not as a commissioner, and then I'll listen to the recommendation, is that the unintended consequence of adding to the workload for items that may settle at the last minute and then do not have to go to hearing. So that's the only thing. Again, not understanding exactly how this works, that would be my only concern. Is it would that, if we say it has to be anything that settles that, we have to be notified 10 days in advance, then does that mean if it settles 5 days, then we still have to hear it?
Well, I think that is the challenge. I mean, if they settle, then there's no point in having a hearing on it, is there? And I don't know, I was going to ask Commissioner Overturf how that works in the context she referred to, but I didn't want to extend the conversation. I think, I'll do that offline because I am curious. I've thought about it and I came up with the exact same answer that Mr. Rouse gave you, is the need for them to settle. We can't make them try a case they don't want to try once they settle. I think for today, if Ms. Hazelton got the orders prepared for the ones that were raised this morning, I think staff is okay with those. It is that last procedural step of getting the orders and hoping that they don't have errors. I would second your suggestion, Mr. Chairman, that we don't entertain that kind of request in the future. There are deadlines. Yeah. If you can't make the deadline, you can't make the deadline. We're busy. They all know we're busy. They can communicate to us if they have priority issues.
So, and I think it's up to the operator. If they have the rig's sitting on location and that needs to be bumped up in the priority, then they need to bring something to the staff on a timely basis so that the staff can inform us. Like, okay, we added this. We chose as staff to add this at the last minute, or we continued something else so that this can get on the agenda. Is that
right? And I'll say this is the second month in a row where we've had this situation. We did the interim hearing last time to appease the operators. It's going to happen, all right? That's the volume we have. If you wait until the last minute to settle, your thing might get bumped. So
All right.
think about that in your settlement negotiations.
clear as mud? Thank you.
Sorry,
Yes,
Mr. Chair.
Commissioner Wong.
I just don't want, the operators to necessarily suffer as a result of too few hearing officers. So if the requests they're making are kind of falling on deaf ears and the calls aren't getting returned or things like that, then, making accommodation by having an additional or interim hearing, might be something, that we consider. But I think you guys should be bringing that to us and asking for that, rather than having it come through public comment or directly, being directly solicited by industry.
Agreed. Thank you, Commissioner Wong. I agree. Thank you. Yes, Commissioner
There's
Hawkins.
not going to be a problem with notice, is there?
notices are good, right?
Yes, they were all noticed for this year.
Yes. The items that we're doing today we're in good shape to get those done. All right. Now we go on to consent agenda items. I believe we have some corrections to make. I think
Yes.
do that, and then we're going to talk about conflicts.
Okay. Mr. Chair, I would just like to remind the commissioners that we have 3 typos should also be Great Western. And on the following page, 171200844, that applicant should also be Great Western. I also, for a matter of timing, Mr. Chairman, wanted to let you know the presentation that's scheduled after the consent agenda on the aquifer study has been pushed to January to make up some of our time. And on that note, it is 4:53 and we are just starting consent. So just wanted to get everybody on the same page.
Thank you for that reminder. All right. The next step in this process on the consent agenda items is any potential conflicts. Yes, Commissioner Boygan.
Mr. Chair, I want to recuse myself from groups A, F, and G. Do you want me to state why, or?
Not necessary.
All right, well then I will do that. And I have mentioned in the past that I have done work for extraction in the past. I'm currently adverse to extraction on several matters, so I don't think that should influence whether I participate on extraction matters. So I'm not asking to recuse myself on those unless anybody has a problem.
No. Does anyone have any? I do not. Does anyone else have a problem? Okay. I will say, go ahead.
Excuse me, I apologize for clarifying. We're considering right now and asking for recusals from just what was on the original consent agenda? Is that everybody's understanding of what we're doing right now?
Yes.
Okay, thank you. Just clarify.
Thank you for that clarification.
And not the enforcement group either. This is
Not
just
we are.
the application
This is just the
consent.
applications groups A through N, and then Group B, which is an extraction matter. I do not have a specific conflict in that. I have done some work for a mineral owner that has some potential income from acreage adjoining those 2 items in Group B, but nothing that would directly involve me with those 2 groups. So again, I don't have an issue with that unless any of the commissioners feel like they're concerned. Okay.
Need a motion?
I would entertain a motion, please, Commissioner Holton.
I make a motion that we approve consent agenda items Group B, C, D, E, H, I, J, K, L, M, N.
Second.
Okay, Commissioner Holton made the motion. Commissioner Jolly has seconded the motion that we approve all the items on the consent agenda, save groups A, F, and G with the corrections made as identified by hearings manager Prime. Sorry. All in favor?
Aye.
Motion carries. I should say opposed, same sign. Motion carries. Okay, now we will entertain a motion for groups A, F, and G. Again, this is just on the consent and agenda items, not the ones we've added and not the enforcement items.
So moved.
Second.
Motion made by Commissioner Holton, seconded by Commissioner Jolly. All in favor signify by saying aye. Aye. Opposed, same sign. Motion carries. Now, we shall move on, I believe, to the enforcement administrative orders by consent. We have 3 items on the group. Is there any way we would like those address those differently than as a group? Commissioner Overturf.
Yes, Mr. Chair. I have some concerns with the first the first enforcement matter on consent. I don't want to belabor our hearing, however, and so rather than pulling it off the consent agenda and having a full discussion, I would be fine with simply proposing to vote on that matter separate from the remainder of the consent enforcement agenda.
Could you say that again, please?
Yes, I would like to vote separately on the first matter that is in the consent enforcement agenda, which
Okay.
is
1706000302.
302, yes.
Okay, so we will pull that out. We will vote on, as all the commissioners, on docket numbers 1709000311, 1710000772, and 1710000649.
So moved.
Motion made by Commissioner Holton,
Second.
seconded by Commissioner Walk. All in favor, please signify.
I just have, I'd like to get a clarification on 772, or just, is the hearing officer here? Is this the appropriate time to ask?
You just squeaked in under the
Well, I
wire.
mean, yeah, well, I don't want to pull it, I just would like to know, read my notes, it's been a long day. Are there more orphan wells coming from this company? Dunning?
Good morning, commissioners, or evening, I guess is where we're at. This is David Beckstrom, Assistant Attorney General. I represent staff on all three of these AOCs before you on the consent agenda. With me is Stephen Moss, COGCC Enforcement Officer, who also worked on the Dunning matter. I would like a clarification of your question, please, Commissioner Jolly. In this instance, Dunning doesn't have any orphaned wells. They have a number of wells that they continue to operate. Oh, looks like there might be a typo there. Yeah.
So these are not orphan wells?
They're not.
Okay.
Looks like there's a typo.
There might be a typo in this.
Yeah.
If there is there a typo in the agenda?
Kind of threw me off.
Just repeated the Whiting one under the Dunning
Right.
one.
Yeah, commissioners, it has been brought to our attention that there is a typo in the agenda as it relates to the Whiting matter, which does involve a public project to plug and abandon a number of wells formerly operated by Red Mountain, and the Charles P. Dunning LLC matter that does not involve any orphaned wells. So I'm more than happy to respond to questions related to the Whiting matter, which is the matter that Commissioner Overturf asked be pulled from the group vote of the consent agenda items.
So, Mr. Chairman, may I?
Yes, Director Lepore.
If Mr. Jolly could specify, I think at least I'm confused about which matter he has questions on. Is
Well, I
it
am
the
too,
Dunning
come
matter
on.
or the Whiting matter?
Getting right here. If we suspend 187,000, I guess you have confidence that this is going to get remediated?
So this is in regard to the Dunning matter, I believe.
Yes,
So
it is.
Yes.
in Dunning, this is an operator that has, despite the compliance issues that were the basis of the NOABs, they have continued to work on those issues. They have submitted the Form 4 sundry request for flaring. They have submitted the Form 15 for the pit, gotten it approved, completed the lining of that pit. And that, in addition to the review of financial materials submitted to the AG's office confidentially for review, led us to the settlement you see there. In terms of an opinion as to whether or not everything will be corrected or not, that's kind of the factual information I just provided you. The operator has been working to resolve compliance issues that they have. We don't have any reason to believe that they'll discontinue those efforts. And so that's the position that the AOC leaves us in that we're proposing.
Okay, fair enough. I'm not prepared to push that any further.
All right, so you are prepared to vote?
Yep.
All right, so we're only voting on the 3 listed items, not 170600302. As a group of commissioners, all in favor signify by saying aye. Aye. Opposed, same sign. Motion carries. Now, I'll entertain a motion on docket number 170600302, Whiting Oil and Gas Corporation.
So moved.
Motion made by Commissioner Holton,
Second.
second by Commissioner Walk.
I'm sorry, Mr. Chairman, what was the motion?
The motion was so we pulled out out of Group A, docket number 170600302 to vote on it separately.
Yes.
So this is a part of the enforcement administrative orders by consent. The request of Commissioner Overturf, she asked to have that pulled out and vote on that separately.
I understand. And was Commissioner Holton's motion to approve that?
The motion was to approve.
Thank you.
The enforcement. Sorry, I should have been a little more clear. And it was seconded by Commissioner Walk to approve the motion.
Thank you.
Now we will, any discussion?
I would just like to clarify why I felt like it was important to pull this one out and vote on it separately. I think there's a lot of value in pursuing these types of public projects as part of enforcement proceedings. However, I'm concerned about the specific language of the order, and specifically I'm concerned about the potential transfer of liability from the entity that's undertaking the public project to the COGCC. Specifically, I'm concerned about the language that states that Whiting shall under no circumstances be considered or deemed an operator. There are a number of requirements in our rules, particularly around environmental and public health protection, that apply specifically to operators. And I'm afraid that that kind of a blanket exemption may pose problems in the future if this particular operator doesn't do the project in the best possible way. And I also note that under the terms of the order, the COGCC would maintain liability except in instances of gross negligence or malfeasance, I think is what it says in there. But that gross negligence standard seems very high to me. And I'm uncomfortable with the COGCC taking on liability for stuff that might just meet the standard of regular old negligence. So I just wanted to clarify why I had the position I did. Thank you.
Thank you. Any further discussion? Are we ready to vote? Okay. Yes, Commissioner Wall.
Can I ask the rationale for the language?
Certainly.
Commissioner Wolf, Commissioner Overturf, thank you. Again, David Beckstrom, Assistant Attorney General, representing staff in this matter. We're also joined by Joe Piershala, who represented Whiting Oil and Gas Corporation in this AOC, and he can answer any questions you may have as well. The starting place for staff on this public project was that Red Mountain filed bankruptcy somewhat simultaneously with being hit with a significant enforcement order by the COGCC. Red Mountain did not come out of that bankruptcy in any fashion that they could complete any work. The COGCC order required that if Red Mountain did not complete the corrective actions required by that order, its Form 1, its registration for oil and gas operations, and its Form 10, its certificate of clearance, would be revoked by the commission, which did happen. As such, these wells are orphaned. As orphaned wells, they are currently the responsibility and the liability of the COGCC. So that was our starting place, was that these are the COGCC's responsibility. Right now, they're part of our orphaned well program. They are not very high up on the priority list for that orphaned well program because they are generally deemed stable. They're is not a impending environmental damage that could result from these. That being said, they are orphaned wells that eventually the COGCC would be required to go plug and abandon and reclaim. When we entered negotiations with Whiting Oil and Gas, we had a significant penalty that was contemplated and calculated. We looked for ways that we could potentially benefit the state to take care of some wells near Whiting's location. It's in an adjoining county, but sort of the eastern boundary of one, western boundary of the other. As such, the starting place was, these are our responsibility. We proposed to Whiting the concept of maybe plugging and abandoning some orphaned wells. These came up as good candidates because of their proximity to the location, but also because they were a fairly straightforward package to plug and abandon. There's no, again, impending environmental harm that's sitting out there just waiting to happen. And the wellbore configurations, as we understand them, are fairly simple. Therefore, the plugging and abandonment of these wells would be a relatively straightforward task, barring any unforeseen horrors that may be evident once they get down into the wellbore, which is part of the reason of some of the drafting around options that Whiting may have once they get into this project. That being said, with the starting place that these are the COGCC's responsibility, that the liability for plugging and abandonment of these wells, as well as anything that may occur right now, is with the COGCC, we deem that the shifting of risk between Whiting and the COGCC as contemplated in paragraph 2F of the order section was an appropriate balance of those risks. That we retain responsibility for the liability of what's out there. Whiting undertakes the project, and short of gross negligence or willful misconduct, we retain the liability for the circumstances as they exist and as the project moves forward.
Okay with that?
Sure,
Shall we vote?
sure.
All in favor signify by saying aye. Aye. Opposed, same sign.
No.
I think it would be safe at this point, Ms. Prine, to say that we recorded one no vote from Commissioner Overturf and all the other commissioners voted aye. Okay, what is next? What do we have next on the agenda, Ms. Prine? We have a fair amount.
Next on the agenda is docket number 171000702, Great Western Operating Company and Acoma Energy.
Okay, yeah, that's totally fine. Go ahead. Bear with me 1 minute, I'm just gonna pull up a PowerPoint.
Okay. So you want, so the
I think I can try and set this up a little bit.
okay.
Okay, take care of things. Thank you.
So not because of her expertise, but I think because of her voice at the moment, Ms. Hazelton is going to defer to Mr. Davenport to be the hearing officer. So, thank you very much. So Mr. Davenport, if you'd like to set this up for us, please.
Sure, and this is my first time as a hearing officer, so I'm gonna stumble through it a little bit, but I will do my best. Commissioners, this is docket number 171000702. It's a request to pool all interests in application lands. The applicant is Great Western Operating Company LLC. That's protested by Acoma Energy LLC. think I can short circuit the summary a little bit. The commissioners have hopefully all seen the hearing officer's final pre-hearing order, and as I understand it, we have a somewhat limited set of issues here today. The issue, as I understand it, is the facts are relatively not in dispute. And what happened here is Great Western sent out a series of, is everyone familiar with the 530 election materials that go with forced pooling? They sent out 530 election materials that go with forced pooling, and they sent them to certain unleased mineral owners. Subsequent to those offers, 530 material offers going out, ACOMA, the protestant, purchased some of those mineral interests from the parties who had already received the 530 election materials from Great Western. ACOMA's issue is that they believe they are entitled to receive 530 election materials on their own in a new election period. My understanding, however, though, at least this is what occurred at the final pre-hearing conference, is Great Western is willing to give the 530 materials and an extended election period. At least that's what they indicated at the final pre-hearing conference. And maybe at this time it's appropriate for me to ask Great Western's counsel if that offer still stands.
It does. This is Kelsey Wazelinki, Jost Energy Law on behalf of Great Western. And yes, that offer does still stand. Great Western has offered multiple times to extend the election period for ACOMA, and it has actually proposed some order language that I can put up for you, which would extend that election period an additional 35 days from today.
So then, unless there's objections from the commissioners, I think it's appropriate to ask ACOMA exactly what relief is remaining that the commission can give them.
Thank you. This is Rob Willis with the Shaner Group Law Firm. I'm here with my client, Matthew Anderson. He's the owner of ACOMA Energy. What relief I'm requesting of you is basically that the application be continued for the 35-day period where my client can consider these materials, which he has not yet seen. He has never received these. He made several requests in the month of October for them. Anyway, so some of these are factual issues, but I think that's what he wants, is the opportunity to participate through either a reasonable lease or bear his own costs through the 530 materials.
So then, commissioners, it appears that is the issue before you, is whether or not to continue the pooling application to give ACOMA time to consider those 530 materials in advance of the commission entering that pooling order. I think you have a couple of options available in front of you right now. Then the first one is that you may allow the parties some time to make their presentations to you in that regard. The second one is you may decide if you need to hear from the parties at all yet on this issue, and recognizing that the parties may want to say something. And if you decide the option I just presented you, they may wish to still speak to you about that. But I think at least initially, those are the two options that you have, is if you're ready for a motion now, if you want to hear from the parties on that issue. But as I understand it, that's the only remaining issue, is whether or not to continue this pooling application.
May I ask one question? Mm-hmm. When did you receive the 530 materials?
My client has not received the 530 materials.
Oh, not yet received them.
May I ask a
May I
question?
respond? Yes.
Just a moment, Commissioner Overturf. Would you like to respond to that? And then I'll ask Commissioner Overturf. Yes.
I would like to respond. And I know it's in the record, but Great Western did send those 530 materials to ACOMA's predecessor in title. And ACOMA recognized in a letter that's in the record that it sent to Great Western that it calculated the 35-day period. It said, we would like to make an election before the election period expires on or around September 4th. So it acknowledged that it knew of the election period. Also, Great Western put the 530 materials of record in this matter. They were exhibits to our 511 testimony. They were exhibits to a motion to dismiss. It's the same election materials that were sent by Great Western to ACOMA's predecessor in interest.
Okay. Commissioner Overturf, I'm sorry. Go ahead.
In addition to having notified the
that's the case. That's when we had dialogue
So did you not accept it then?
Well, we just never received the materials.
But they were offered to you, right? Is that, I'm just making sure I'm reading.
Well,
the
I
order
wouldn't,
correctly.
I wouldn't say they were offered to
They were
us.
offered, excuse me. They were
They
offered.
indicated that they were going to provide them to us. Is that offering? Maybe that's offering. But they never provided them.
Okay.
And I do want to say it's a stipulated fact that that offer was made on October 26th. That's not in dispute.
Yes.
Mr. Chair, if you want me to venture out there, I'll do it.
Commissioner Boygan, yes, briefly, if you'd like to venture out.
Okay, so what I'm hearing COMA say is that they want to hold up a pooling application covering some 1,923 acres because for their net 2.5 acres, they want everything else to shut down while they consider the same materials that Great Western offered to them on October 26th, and which Great Western, in my opinion, was under no obligation to offer to them because Great Western had timely, in accordance with the rules, offered it to Acama's predecessor in title. So I, for one, do not intend to support any kind of a continuance or delay or interference with the pooling process here. I think frankly, this whole proceeding should not be in front of us. I don't understand what Acoma is trying to accomplish other than essentially to extort some kind of a settlement from Great Western in asking for this kind of delay.
Commissioner Boygan, thank you very much. I believe each party is only limited to 15 minutes for a presentation. I think we should go ahead and hear that. Mr. Davenport. Yes, go ahead.
I do have an alternative suggestion for commission consideration.
Okay.
We have the single issue about a continuance. I think if the parties want to, they can put their best foots forward on that issue. I know we've already asked some questions, but you don't have to necessarily give the parties their full 15 minutes to put their best foot forward. You can also just ask the questions that you think you need to ask and then make a motion. That's an option to you too. So I'll leave that up to you. I think you have those three motions. Do what 15 minutes each to do what they will as the hearing officer ordered. Some less time for that to argue the sole issue in front of you, or simply ask the questions that you'd like to ask and then move as you will. I'll leave those options up to you then.
Commissioners, your pleasure. Just some brief comments. I heard what you had to say, so I think, you sort of read the materials, you know where you're headed on this. Any other commissioners? I think you've spelled it out fairly clearly. We could say, briefly summarize in favor or not in favor of a continuance, because that's the only matter in front of us. We can ask a few questions and decide to vote on whether or not to continue, or something else. Commissioner Hawkins.
I just have one question. Are there, one and then maybe another, are there any other unleased owners that are being force pooled that did not protest?
There are no protests of record other than Acoma in this matter.
I mean, are there other parties being force pooled then?
Yes, there are unleased owners being force pooled pursuant to the rules in the statute.
And they all received the same offer to lease?
They did.
Okay, thanks.
Anyone else?
I got a long-winded comment.
Not for lease.
I agree.
Yes,
with
Commissioner Holton.
Boygan.
Which would be what?
I agree with his assessment.
So does that mean you're prepared to
Deny the continuance.
deny the continuance?
Could we have an opportunity to be heard with
I
regards to some
think
of the issues?
we probably should at least let them be heard.
The only thing I'd really like to know is how you think that you're going to be harmed in this if it's not continued. And you get the information, you get the 35 days, how are you going to be harmed?
How fast can you summarize that?
Well, I don't think we're going to be harmed. We want the additional time to look at the materials. That's what we're asking for. We've never had the opportunity as an interest owner who received these interests in fee prior to the date the application was filed. And I think that's the critical distinction that I'd like to make, is whether or not these materials were given to the predecessor in interest. The rules talk about the pooling of interests being as of the date of the application. We had interests as of the date of the application, but we were never provided with the materials to give us an election as to whether or not we wanted to lease or bear our costs. And even though we asked for them on numerous occasions.
All right, so I will butcher your name, I'm sorry.
It's okay.
Is it Wazelinki?
Correct. Wazelinki, that's good.
Wazelinki. With the materials that they're requesting, are those the same materials that were provided to the predecessor
They
owner?
are. They are the same materials.
So did you get to, I would have assumed in your due diligence process, when you acquired those interests, those materials would have been available to you. Why were they not available to you?
Mr. Anderson wasn't, he ended up talking to, I believe, a different owner within the application lands and was made aware of the fact that the pooling application had been filed. And this was back in probably September or early October. And that's when he started the process of reaching out to Great Western for his own election. He even though he's an interest owner of 2+ acres, he should be afforded the same due process as others.
2 or 200. I don't think that quite answered my question, because there was an interest was acquired, 2.5 acres were acquired from another party that was provided the materials as part of the application process. Why would that not have come out in the due diligence process, that those materials were should have been there in the information that came with the acquisition? Why were those not seen?
Oh, okay, I'm sorry. Yes, he asked for them from that owner when he purchased them, but they were unsophisticated and didn't have the materials.
They threw them away.
I'm not sure.
Who knows?
May I ask a follow-up question, Mr.
Yes,
Chair?
Commissioner Overturf, go ahead.
Let's say that that's correct and you didn't receive them then. Again, it is a stipulated fact in the final pre-hearing order that you were provided an offer on October 26th. And as I calculated, 35 days from that offer would have been November 30th, which is well in advance of this hearing.
Right, and I can respond to that.
So notice seems entirely adequate.
Well, and I can respond to that, but if you notice with regards to the stipulation, the offer to lease was provided my client on that day. But it's more than that under the well election materials. There needs to be an offer to lease because he owns the interest in fee. He needs to get the offer to lease as well as an AFE to check the AFE to make a decision as to whether or not he wants to participate and bear his proportionate share of costs.
Can I clarify that point?
Please.
So on October 26th, both an offer to lease and an offer to extend the election period was made. So inherent in that offer to extend the election period is that Great Western would provide the Rule 530 election materials at that time. But ACOMA decided to maintain its protest. And so Great Western did not send the 530 election materials.
So it was, the offer was made, and had they said, we want to see that, you would have given those materials to them at that time?
That's correct.
And when they refused, they said they want to continue to protest. You said, okay, we'll see you in front of the commission.
That's correct.
Commissioner Jolly, I think you had a question?
No.
Okay. All right. Interesting. We sort of leapt into this. Is it possible that you could maybe summarize this in 5 minutes or so?
Yes, absolutely.
Okay.
I think it'd be helpful if I just walk through a timeline.
Okay.
So we know that we're subject to Rule 530 and the pooling statute. So these are the undisputed facts. Did ACOMA receive notice of the application in compliance with the commission rules and the Oil and Gas Act? Yes, they admitted that they had notice of the application on or before October 19th, which is 52 days before the hearing in this matter. ACOMA is in the administrative record in this matter, and the hearing officer found no good cause for continuance to the January hearing. Second undisputed fact is ACOMA entitled to Rule 530 election materials for its interest that it acquired within the 35-day election period. And Great Western's response to that is ACOMA's predecessors in interest received the Rule 530 election materials. And as we've discussed, Great Western offered to provide ACOMA with election materials and extend ACOMA's election. So quick run through of the timeline. Great Western started its title in these lands in 2014, which it did through 2017. On June 30th, well ahead of filing its application, Great Western sent out a pre-notice letter in addition to an offer to lease to all unleased owners of record. And at that time, ACOMA owned no interest in the application lands. On July 1st, Great Western deployed its lease brokers to commence contacting all mineral owners to negotiate offers to lease. On July 30th, Great Western mailed well proposals and elections to all working interest and unleased owners. At that time, ACOMA did not own any interest in the application lands. So between August 7th and the 11th, the 35-day lease offer requirement was met per Rule 530. Between August 14th and August 30th, ACOMA acquired certain interests in the application lands. And I will say that when ACOMA alerted Great Western of these interests, there were significant title concerns with those interests. The majority of those interests were in fact leased, meaning they weren't entitled to an election or an offer to lease. A small majority wound up to be unleased, but at the time ACOMA alerted Great Western of the acquisition, the title had not been verified. On August 31st, Great Western filed this pooling application. Between September 4th and the 8th, the 35-day election period expired. On October 19th, ACOMA filed a letter with the commission alleging that Great Western didn't comply with the rule. The hearing officer then continued the application to this hearing date and gave ACOMA 10 days to file a Rule 509 compliant protest. So they've clearly been given significant due process. On October 26th, Great Western remitted to ACOMA an offer to extend ACOMA's election period and offered to lease ACOMA's interest. That's an exhibit of record. It's exhibit number 4. On October 27th, ACOMA and Great Western met to discuss the lease offer and the election. On November 3rd, ACOMA filed a protest to the application, which it later amended on the 6th. On November 30th, Great Western finally ended its leasing efforts. And on December 5th, a final pre-hearing conference was held, which resulted in the December 8th order, which reviewed the stipulated facts and the issues in front of you today. This is Exhibit 6, which acknowledges that ACOMA had knowledge that the 35-day election window expired on or around September 3rd. That's Great Western Exhibit number 6. And that is a letter dated August 30th from ACOMA directly to Great Western. They said, we would like to either participate or ask a lease offer from Great Western to allow in the order. ACOMA Energy will have up to and including January 16th, 2018, which is 35 days from today's date, within which to notify Great Western in writing if it intends to lease or participate in the wells. Should ACOMA fail to notify Great Western in writing of its intention to lease or participate in the wells by January 16th, 2018, or elects not to lease or participate before or on the stated date, ACOMA Energy will be deemed non-consenting as to the wells and be subject to the penalties provided by the statute. So our request at the end of all this is to deny ACOMA's protest, to approve Great Western's pooling application, and I think you have two options there, to either confirm that ACOMA is pooled and subject to cost recovery by Great Western's compliance with Rule 530 by sending those election materials to ACOMA's predecessor in title, or alternatively to approve Great Western's pooling application with Great Western's proposed language in the order.
Could you go back to that language, please, so we can look at that? Okay. Mr. Willis, we'll give you the same length of time.
Thank you. I appreciate you spending time with me at this late hour. What's important, I think, to understand from my client's perspective is, that isn't enough, right? Because that doesn't comply with what the rule basically sets out. And it's kind of the foundation of it is in due process in administrative law, and that's notice and opportunity to be heard. He maybe has that opportunity to talk to you today, but the rule, and there has to be some kind of import and precision to the rules that you're operating under. And so I like to look at this as kind of like a flow chart in my mind. First off, if you're going to pool interests, if you have a desire to pool interest because you don't control everybody within a unit area and you can't abide by setbacks, then you come to the commission and you get a spacing order. And then you can pool interests and test to see whether or not there are non-consenting interest owners there and whether or not their interest should be subject to cost recovery and risk penalties. In this particular case, we've got the spacing order was approved. Now we move to the second phase, and that's the pooling of all interests. And when you do that, you need to give everybody notice that you're going to be taking some kind of action on their interest. You're going to involuntarily pool them, because my client didn't have any kind of development agreement with Great Western when this came about, when he acquired these interests. And that's why it's important to note when he acquired these interests were between the dates of August 14th and August 30th of 2017. The pooling application was filed on August 31st, which was after he acquired the interests. And so the language under the Rule 530 says that the pooling order is effective as of the date of the application. There's a provision there that says that, right? So he's entitled to the same due process as any of the other interest owners, not through his predecessor in interest. He's got his own right to that. And that's a packet of information. You've all seen it in your materials through the time you've been working as a commissioner. He owns these interests in fee. So he's got an opportunity to look at a reasonable offer to lease. He also has a chance to look at an AFE to see whether or not he wants to participate. And then he makes the election and he sends it back to the operator within the 35-day period. And so that's mechanically how it's supposed to work. And for you to just say, well, we'll approve the order now, we'll approve the application with this language, denies him the opportunity to look at that and make a finding of his own that the offer to lease is not reasonable based on what he knows other lease offers are in the area. So what's he supposed to do if he's not satisfied with those materials, or if he thinks the AFE costs are not reasonable based on the development of any of these 26 wells that are proposed to be drilled during the forced pooling period? So, I mean, what's his check? Well, I submit to you that he should be able to come back to the commission and he should say, hey, this is not a reasonable offer to lease. This is not a reasonable AFE. And if he doesn't have if the application is approved, does he have that right or remedy available to him? I say no, he doesn't, based on that language. So I mean, that's where my client's head is in this whole process. And he made several opportunities or several requests of Great Western to get these materials to where he could have 35 days to consider them before the application was going to be approved today. But they never sent the materials. They never served him legal notice of the hearing. He had to figure that out on his own. They never have given him the packet of materials, and they're basically trying to bootstrap, exhibits that they filed to their motion to dismiss to say that gave you the opportunity to participate. That's the well proposed materials. Is that what your rules say? That's not what your rules call out. So, I mean, we just want another 35 days that we feel we're entitled to look at these materials before you approve the application.
I would like to ask a staff opinion on this, if you don't mind, Director. It sounds like, from what I've heard, is that their belief is that there was adequate time to peruse those materials because what I saw in there is they were made available more or less at some point in time in that process, because I think there was a letter in there that says acknowledged receipt of the materials.
Can I?
No.
Yes, Commissioner Dowling.
Am I missing something here? Aren't they offering you 35 days right there?
Well, they are offering us 35 days, but we're requesting that you continue the application to the next cycle. So we would have an opportunity in that time period, if we make an assessment or determination that the materials that we provide don't meet what your rules require, which is reasonableness, or a just and equitable AFE cost, or whatever the language is, that we call that out and say, hey, this isn't right. Otherwise, that just basically says they could throw us anything, I suppose. They could give us an offer to lease at lower than what market conditions dictate or require. And then where do we go?
Mr. Chair, could I ask?
Yes, Commissioner Boygan. I'm sorry to drag this on, but
Well, so the way I'm sizing this up is you're first saying that the way you interpret the rules, setting the election materials before the pooling application is filed is invalid, right? You're saying
I think
because they sent the pooling materials out before they filed the pooling application.
well, they
So
said
all to the owners of record.
To the owners of record.
And your client, I understand, was not of record at the time they sent the materials out. Okay, so you would have us adopt a rule that says, number one, you can't send out the election materials until after the pooling application is filed. And number two, if between the time they send them out and the time the application is filed, ownership changes hands, then what they sent out is invalid. And it's not only invalid as to the owners for whom it changed hands, but it's invalid for everybody, so that the whole process has to start over. Putting it another way, aren't you saying that for 1,920 acres of this pooling application that have not protested, have not sought a continuance, have not objected, and are effectively ready to go on this pooling application, they have to be drug along for another, until the end of January, for a continuance for your client's 2.5 acres to decide what he wants to do, because he doesn't have a remedy otherwise, when he could file an objection with the commission saying, all right, I've looked at the stuff. The offer they've made me is not reasonable. It doesn't comply with the rules. I object to the proposal they're making to me, and I want some relief from this specific proposal as to my 2.5 acres.
If I could respond.
Sure.
Certainly.
I think that what I'd like to draw your attention to again is that the key date is the date of the application. They chose to serve those materials before, and some of those deadlines lapsed during the time period that my client then acquired those interests. So it's not on ACOMA. It's on them to cure that defect, is it not? And so they come back to Mr. Anderson at any stage after the application has been filed, and they give him those materials, and that's exactly what he required, Mr. Boygan, back in October. He required several times an opportunity to have his own election and these own materials to review, and they never provided them to him.
So I don't have anything more to say.
Thank you. A brief question, Ms. Wazelenki.
Yes.
The materials, if the order ends up being something like this, would the materials that you provide ACOMA be the same as what you provided the original owners? Exactly the same?
Correct.
Same terms as everything?
Correct. Same terms. And I will say, again, because I think it's getting lost here, ACOMA did receive an offer to lease from Great Western on October 26th.
And
It has never been alleged to be unreasonable.
There was a number in there.
There was a number. There was a royalty. There was a term. There was a bonus.
So you can either, for our rules, you can either lease or go non-consent or elect to participate.
Or participate.
Yes?
I was never provided the information in which to make my election. I didn't know how much each well was going to cost. I didn't know the cost of drilling nor completion. I requested it via USPS sign receipt twice, and they refused to acknowledge the letter or send me anything. And I did so within the 35-day time period.
I'm sorry, I apologize. This is
Go ahead.
Kyle Davenport. I need to raise just a procedural issue. Mr. Anderson is the client. He's not an attorney. So if he's going to testify, we do need to swear him in.
Sorry. I just adopt that as an offer of proof. I could provide that to the commission.
I think we can swear him in. It's just going to take a minute.
Take a second.
Would you, Mr. Anderson, would you stand up for a minute, please? And raise your right hand, please. Do you swear to tell the truth, sir?
I do.
Yeah, thank you. You can sit back down now.
Certainly.
So Ms. Wazelenki, again, the materials, when you sent out all the materials in August, it included an AFE, and was all that provided?
It was. That was on July 30th. The election letter, the AFE, there were for 26 well-specific elections. So each owner had the opportunity to elect in a portion of, or all 26 defined wells, 26 AFEs. That's correct.
So I guess this
So at that time, Great Western said, relied on the fact that it had sent Rule 530 election packets to all owners of record at the time it sent those packets.
So then it
Since
goes.
that time, the packet has become record in this proceeding. It was filed with Great Western's Rule 511 testimony, and the exact 530 packets and AFEs and elections that were sent to ACOMA's predecessors in title were attached as an exhibit to a motion to dismiss that Great Western filed.
And that would be exactly what's going to be in this offer
That's
as well.
exactly right.
No change on the AFEs
No
list
change.
or anything. The date's all the way back to June when you first sent that out?
July 30th.
July 30th. Thank you. Sorry about that. Mr. Willis.
He just never got the materials addressed to him, right? Which I think the rule requires. It doesn't say predecessors in interest are acceptable service. It doesn't say that.
I just
An
feel,
owner of interests, and the date of the application is key. When you look at the rules, that those individuals need to be provided materials, and he was not provided materials that were addressed to him. I suppose he could have dug them out of the exhibit. He saw them, I assume, in the exhibits, because I forwarded all that material to them, and he would have had some time to consider them. But he made continual requests throughout this, and many times, just for his own packet of materials, and that was refuted by Great Western.
I just like to make it, I think
Yes.
we're belaboring this point.
I know.
And I fail to see what remedy you would afford to ACOMA other than an extended election period. Notwithstanding the fact that Great Western did provide that already to ACOMA's predecessors in title, we're willing to go above and beyond the requirements of the rule and say, you can have 35 days from today. We won't apply non-consent penalties. So I fail to see what additional remedy ACOMA is trying to seek from this commission.
That's, I mean, to me, you're offering, I think as Commissioner Jolly said, you're offering 35 days. Your terms and conditions have not changed from the July 30th. Is that correct? They're all
That's correct.
exactly the same.
That's correct.
So you're getting the 35 days.
Yeah, but don't you need to abide by the rules?
Well,
Before you get the relief at the back end? Don't you need to give him the 35 days before the application is approved? That's not what this says.
I'm going to ask the hearings officer, what does the rule say? Help me out.
Well, I can certainly read the rule to you. It says that in regard to the 35 days, an owner shall be deemed a non-consenting owner in the area to be pooled if, after at least 35 days written notice of the following information, the owner does not elect in writing to consent to participate in the cost of the well concerning the pooling order which is sought. The information is location, objective depth of the well, estimated drilling completion costs, estimated spud date, and authority for expenditures also to be sent. Same language similarly for a lease.
Yeah. I'm sorry, Mr. Willis. What I struggle with is that those materials were made available to the interest that your client acquired. Would have had those had he, and I understand he made a request from them, didn't receive those.
Right, I mean, I guess, yeah, that would have been the solve, the elixir would have been if they would have provided him those materials when he requested them. That's what my client is here to tell you. And they did not do that. And I'm telling you, at least my interpretation of the rules requires there to be some kind of sharing of information with ACOMA prior to granting this application pooling interests, because he was an interest owner as of the date the application was filed. And they never sent him those materials. So, I mean, why is that on ACOMA versus Great Western? The remedy was with them, and they never availed themselves of the opportunity to provide those materials to my client.
So the dilemma being that your application occurred after ACOMA acquired the minerals, even though you supplied the materials before, is that correct?
And I would just like to clarify a point here. Mr. Willis has represented that had Great Western just simply provided the materials, we wouldn't be here today. But we offered that on October 26th, and it was not accepted. I think there were other allegations in the protest that go beyond this commission's jurisdiction. And I'll go as far to say we're abusing your processes and procedures right now by even being here in front of you on an issue that, frankly, I still struggle as to why we're here.
So do I, but I'm just trying to understand it. I think I probably beat this to death, and I apologize for that.
Commissioner,
Yes.
may I please?
Yes, you may.
If
Sir,
If they want,
would you please identify yourself for the
Sure.
record before you speak?
Matthew Anderson, Acoma Energy. If they wanted to make the offer and provide me the documents, I see a problem in the fact that they still have not. They want this to be in effect, but yet they still refuse to send me all the required documents via the statute. One problem. Second problem, I provided them notice within the 35-day period of my predecessor's election period, provided them notice that I was the new owner, and all I needed was a full and complete packet, because how am I supposed to make a decision if I buy an interest from an individual whom I don't know if they provided me with their complete documents? I think if I had come in the 11th hour before spudding of the well and said, I need my documents, I think that would be a bit onerous. However, I gave them 16 days within that 35-day period, I believe, to just send me either the packet or the email. And in fact, in the email that you saw that my office sent to them, I actually said, we would like to probably, or I think we would like to consent or lease our mineral interests. However, we do need to make sure that we have all the documents. All I did was ask them over and over and over. Now, if for some reason they refuse to provide those documents to me, which they still do, how am I supposed to make an election on a tract of land or multiple tracts of land that have effectively been pooled?
Mr. Chair,
Yes.
I think we
Commissioner
have gone far beyond the 15 minutes that was allocated to each party, and I would move that we call the question.
I would be happy to do that, although we need a motion at this point on what we're going.
I'm moving it. Do we need a motion before we can?
I think we have to
move
close the record first.
Okay,
No,
then I would move that we close the record.
okay, just a minute. Mr. Davenport has something to say.
Okay, I have a quick question to satisfy myself. I apologize for slowing everybody up. Will you go back to the language that you've proposed? Is your position, Ms. Wozzelinski,
Wozzelinski.
Okay, sorry. That they already have the 5:30 election materials?
We would be willing to provide those right now, today. Great Western's position is that because their predecessor had them, that was the burden of Acoma when they acquired the interest to do the due diligence to get those election materials. But again, Great Western's willing to go above and beyond the requirements of the rule and the pooling statute and provide those materials today.
Okay, so if you provide those today, January 16th is 35 days
35
after
days
that
from
period.
today.
And you are committing that you'll provide them today?
That's correct.
Okay. What happens?
I will say, thinking about it, we're after business hours right now at that.
Do you
I would
have
say
any
by
objection
close
if
of business tomorrow.
Close of business tomorrow, 35 days, January 17th. What happens if Acoma does have an objection to the materials that you provided? Are they, under this language of the rules, you read it, are they automatically force pooled even if they have an objection?
Yes, they have had these materials. They've had knowledge of these materials for quite a while now, well over 35 days. And they have never alleged that the offer to lease was unreasonable. And they have never alleged that any of the election materials were unreasonable. And they've had notice for 52 days of this application.
Commissioners, I'm sorry, Commissioner Wolk, go ahead, please.
No, go ahead. As
my own opinion, I don't know what else relief you can give Acoma other than just what's been offered by Great Western. And so take that for what it's worth. That's my assessment, but I apologize for having to clear up when the 5:30 materials were provided, but that was the purpose of my questions.
Wouldn't another form of the relief be to continue the application?
No.
That was one of the things that we came up with initially, is that one of the forms of relief would be to continue the application. But I'm mindful that what Commissioner Boygan has said, that, and myself also, is that there were some other ways to get hands on the materials some time ago. And
Sir, I tried diligently.
I'd also just like to state for the record that the hearing officer found no good cause to continue this application to January.
And I was mindful of that, as I think that was the staff's opinion. There's no good cause to continue this into January. And I think, yes, Commissioner Wall.
Mr. Chair, I move that we close the record.
I second.
Okay, actually, we don't have to vote on that, I don't believe, but I will accept that let's close the record. I think we've heard everything we need to hear. Is that okay, Mr. Davenport?
Mr. Chair, do you have another issue does anybody that you'd like to raise with the application?
The one thing that came up is that how does this, because it's AFEs for 26 wells, correct?
Correct.
And how do you contemplate developing, so we won't close the record just yet, sorry. How do you contemplate drilling those wells? They're going to be all 26 at once?
Well, I'd like to back up a little bit if I may. So
Certainly.
we are seeking to pool a drilling and spacing unit. The
Okay.
commission has entered multiple orders seeking to drill multiple wells in drilling and spacing units. The election materials that have been provided are well specific AFEs, specific elections. I can't speak myself to how Great Western is going to develop these, but I don't see how it's at all divergent from the rules or statute to pool up to 26 wells in an approved drilling and spacing unit, which has been approved for up to 26 wells.
Understand that. So let's assume for a moment, do some hypotheticals here, that Great Western submits all the AFEs. Is it your understanding that Tacoma has to make a decision to participate or non-consent in all 26 at once?
That's right.
We're getting individual well.
Yeah.
You're getting it. So again, it goes back to what sort of a range of time you could do those 26 wells all
that a certain amount of wells can be approved and pooled, and a certain amount later, there's going to be vast uncertainty in that development, particularly for the operator and those owners who are willing to take the risk of that development. It would maybe lead to a cherry picking type situation. And, you know, again, I think we're here in front of you today, having had this issue never raised until the day of the hearing, and just respectfully would say that Great Western has complied with Rule 530 and the pooling statute and seeking to pool all interests in these lands.
And I'm not concerned about that part. What I am concerned about is the opportunity that if some of the wells get delayed for some reason, then Tacoma gets, how do you create an opportunity for Tacoma to participate in subsequent wells if for some reason you don't drill half those wells till 2 years from now?
Well, I will say Great Western is intending to drill all of these wells, I believe, at one time, I think for economic reasons. And I will say they have the opportunity via all of the information provided by Rule 530 to make that election.
Okay, so then you wouldn't, so then based on that, if there's the intent or the assumption that you're going to drill all 26 at once, you wouldn't be opposed to saying that if half of those wells or some of those wells are spud within 1 year from now, that Tacoma would have an opportunity to participate in those wells.
Great Western would oppose that language in the order.
Mr. Chair, could I just ask?
Yes, Commissioner Boygan.
How does this differ from any other pooling situation? Why would we carve out a special arrangement for Tacoma that we don't make for every other person who gets a?
It's not. I'm just asking the question, is that that it's been raised as with respect to these pooling orders, how this works. So,
okay.
So the question was brought up at some point.
So
yes,
maybe I can apologize. Please go ahead, Commissioner.
John.
May I ask how many other mineral owner interests there are? I saw the pages. I mean, do you know off the top of your head?
It's about 3,000.
About 3,000?
And Great Western
So-
has confirmed approximately 33% of the owners in the unit are being statutorily pooled.
So, Mr. Chair, if I may.
Yes, you may.
I think the issue that's being raised is the commission routinely pools all interests in a unit and then declares people who have not responded or chosen not to elect to a certain number of wells to be non-consent in pooling orders. To my knowledge, I don't know if 26 wells is the most that have ever been approved to declare everyone who hasn't responded non-consent. or not, but it's a very high number for the commission. I've seen 8 and 12, and maybe our hearing officers can chime in, but I haven't ever seen as high as 26. And so I think what you're getting to, Mr. Chair, is the fact that there may be a concern that what if 5 of these wells that are approved in your pooling order are drilled in the next year, and then no wells are drilled for 5 years. You as a commission have an obligation to enter pooling orders on such terms that are just and reasonable. And I think it makes sense to consider whether or not it is just and reasonable to force pool folks in wells that may not be drilled for many, many years from now, in which case circumstances may have changed substantially. And I think one of the things that you can consider is making this order time dependent, in the sense that if the well is drilled in a certain number of time, if any of the 26 wells or all the 26 wells are drilled in a certain number of amount of time after the order is entered, then for those wells, the non-consent fits. For wells that are drilled afterwards, those wells must be re-AFE'd, if that's a concern to you, I think that's what you're raising. Is that correct, Mr. Chair?
We have addressed that before. I can remember some time ago when we did put some time dependencies on participation on forced pooling, because we were concerned, perhaps not in the case of Great Western, but we were concerned about the efficacy of the operator to proceed. And, you know, it had looked and smelled a bit like a land grab. And so we did put some of that in place.
Mr. Chair, I have no objection in the abstract to debating that issue in the appropriate context. I don't think this is that context. This involves a 2.5 acre mineral owner seeking to delay a pooling application, not for that reason. He hasn't raised that objection, but for the alleged reason that he hasn't had time to look at the materials that he's had the ability to have for the last several months, and which I think as a legal matter, he wasn't even entitled to get because his predecessor got it in a timely way. So I'd like to end this and vote.
Okay, so I heard what you had to say. I think we've had any further discussion. And Mr. Davenport?
Counsel for Great Western like to speak. We haven't technically closed the record yet, so
okay,
that's up to you.
You may speak, but we're going to give Mr. Willis an opportunity to say something also.
Well, this is just a clarifying point for Mr. Davenport's comment on the not seeing up to 26 wells pooled in this instance. We actually went back and did some research back to 2015 about what I'm going to call higher number pooling applications. And even in the first one we found actually was dated July 20th, 2015, where Extraction in order number 407-1349 pooled 25 wells in a 1,280 acre unit. And all of these orders that we went through, none of those had that time period limitation. Chairman Benton, the time period limitations, at least that I can recall in recent years, were tied to the unconventional resource units. And those were obviously on a much different development scale as of here, because those were new, those were very unique to horizontal development. And the pooling context of timing came up in the unconventional resource units. We have not found any pooling orders in the recent past that actually tie the timing on these higher number of wells to a specific time period. So I just want to bring that up for purposes of clarification.
One or two back prior to that, but I've slept a few nights since then. Right. So
thank you.
All right, Mr. Willis, we'll give you an equal opportunity to say something, then we're going to close the record and vote because we have beat this to death.
Can you give me just a moment? Just for a second, just 30 seconds.
30 seconds.
Well, I guess just for clarity, again, this would be a point of clarity then. If that provision is incorporated into the long order that flows from this case, if my client feels that those terms that are provided to him are somehow onerous or not reflective of what is reasonable in the market, and the AFE costs are not reasonable, can he come back to the commission then and address that issue?
Mr. Datton, excuse me, Roland.
Well, let me look at the statute real quick, and if Great Western would like to respond to that question in the meantime, that's fine with me.
And I would just say this, since it's still my turn, but I haven't actually stopped talking yet, I would think we'd be able to come back and seek modification of the order, a reopener into the order then, to have some due process. At least I hope that would be built in and recognized if we want to come back in and modify the order or have it amended with regards to him being deemed a non-consenting owner, possibly. I mean, that's a severe sanction against Tacoma and their real property rights.
I think we'll listen to that, but I think it's going to be how the motion comes forward here at this point is how it's going to end up, what the order is going to be. So,
And if I may briefly respond.
yes.
Again, Acoma has never once alleged that its lease offer or the terms have been unreasonable. So this is, this is a first time of, right. And Great Western is seeking to pool all interests in a drilling and spacing unit. I think if there's issues that with Acoma, it should not at all delay the pooling of the unit, which we're requesting today.
And the other 3,000 some odd interest.
Exactly.
Owners. Yes. Mr. Davenport.
So the question was whether or not Acoma could come back to the commission after the pooling order is entered, assuming it does not give a provision for it to come back. If it's, first of all, Section 108 of the Act, Part 7, Subpart 7 does provide that any person affected by any order of the commission shall have the right at any time to apply to the commission to repeal, amend, modify, or supplement the same. Our standard pooling order, or all of our standard orders have the language in it that says the commission reserves the right to modify. So I don't want to give a legal opinion on a case that hasn't come up yet, but that certainly seems to indicate there's some ability to come back to the commission.
Right. Thank you. Let's close the record. The chair would entertain a motion at this point.
What are we being asked to approve? What's the matter before us?
We have a proposed language order. We can have a motion to continue. We can have a motion to approve an order, which we have that proposed language. And I don't know if we have any other language in any other order.
I'll move to approve the language in the proposed order.
Really simple. So Commissioner Boygan has moved to approve.
I apologize. I want to clarify if I may. I'd like to clarify what the motion is, Commissioner Boygan. Your motion, if I'm stating correctly, is to approve Great Western's application over the protest with the language proposed by Great Western on their slide, proposed language in order, but also modified, I think, so that by close of business tomorrow, Great Western will provide 530 election materials to Acoma, and therefore the only modification to that language would be that extending the date from January 16th to January 17th.
What he said.
Okay.
Second.
Motion seconded by Commissioner Holton. Any discussion? Hearing none, are we ready to vote? All those in favor of, and I think I'll defer. I don't think we need to read the motion again. I think Mr. Davenport did a great job reading that as it said. So all in favor, please signify by saying aye. Aye. Opposed, same sign. Motion carries.
Unanimous.
Thank you.
What do we have next?
In the materials that you were provided, you had a division order and some other documents showing ownership for Janet Scheel. Would you?
Scheel. Janet
Okay.
Scheel.
Thank you. These division orders show the same interests for Marla Henderson.
Hines.
Sorry. And Linda Tallman. We can take a recess if you'd like to make copies and pass them around if you're interested in seeing that. The statute, and it is subsection 118 of the Act, requires that first you make a determination of whether or not a bona fide dispute exists regarding the interpretation of the contract. After my review of the materials, and I believe the hearing officer, we have determined there is no bona fide dispute. Interpretation of the contract, you have jurisdiction to determine this matter. In order to do that, you need to determine that each of the applicants has an interest in the well that entitles them to payment. Again, based on my review of the facts as well as the hearing officers, they do have that interest. You must determine that notice was provided. The documents that have been submitted to you show that notice was provided, that 60 days have passed since the end of the calendar month, and in which the applicants claim they were not paid, and there is sufficient information to properly calculate the amount due to the applicants. The statute specifically provides that simple interest calculated on a specific discount rate at the Federal Reserve Bank of Kansas City is how interest is to be calculated. You have in your materials, and let me get to the Bates numbers, it is pages 30 and 31 that show the calculation of the amount due. I believe you have all the materials to enter an order for payment of these proceeds. I believe that applicants have satisfied the requirements of the Act. You should, of course, satisfy, you can, I guess, count this as a hearing officer recommendation, but of course, satisfy yourselves that all the requirements have been met. The applicants are here to answer any questions you may have. As I said, I do have these division orders. If you'd like to take a short recess to look at them yourself, we can get them passed out to everyone. They were brought by the applicants this afternoon.
I guess the first question is, are we satisfied that everything is in order, or do we need to obtain copies of the division orders? Okay.
No copies.
No copies are necessary. I think we'll accept the materials as provided. So it would seem to me at this point that everything being in order, as the hearing officer has said, then we would entertain a motion to award payment of proceeds.
At first, I think if you have any questions of the applicants, you're welcome to ask them at this time. I think it's appropriate to ask the applicants at this time, and I'd like to do that if I may.
You may.
Have you seen first of all, will you please introduce yourself to the commission?
Yes, I'm Janet Scheel. This is Linda Tallman and Marla Hines. We're the sisters.
Thank you. Have you seen the documents? They're on pages 30 and 31. They're spreadsheets titled Estimate of Royalties and Calculation of Interest.
I don't have what you're looking at.
Okay. I know these were prepared quite some time ago, so if you wouldn't mind coming up, I'm going to hand you my pages, and
Oh, yes.
you've seen those.
Yes,
Okay,
yes, I do
so
have
I'm
those.
looking at Bates label 00030, and I'm speaking to Janet Scheel, and she's indicating to me that she's seen them. Do you agree with the figure?
Well, the dollar per barrel is estimated. We got the volume off of the Oil and Gas Commission production report, so.
I don't think we can hear you, so if you would go back and you're welcome to take this with you if you'd like. But what I'm trying to determine right now, commissioners, is whether or not the applicants, this was a calculation that I believe was done by hearing officer Durancy back in July when this matter was initially set up to go. And I just want to make sure the applicants are in agreement with the amount that was calculated. So
Yes,
that's
we
what I'm
are.
trying to determine right now. You are?
Yes, we are.
Okay.
So for clarification, Bates number 30 says a total of $1,841.79. 31, which is the interest calculation, is $1,932.29. So that, you agree with those estimates?
Yes, as much as we could estimate the dollar per barrel.
Fair enough. Okay.
And that is for each of you?
Yes,
That's not a
that's
total,
each,
that's for
that's
each
each.
of you?
That's for
Yes.
each individual.
Yes.
And that's as of what date?
That is, the interest calculation is to today's date.
That's, okay, so that's current.
That's correct. Excuse me, at the time this was calculated, we thought it was going to be heard tomorrow. It's calculated to tomorrow's date.
It's after business, so it'll go into effect tomorrow, so calculation.
I have one more question.
Go ahead.
Is this going to be an order entered only against Trinity Bay or also against Endeavor?
Just Trinity Bay.
And that's because Endeavor has denied any liability, or you haven't made a claim against Endeavor, or what?
Endeavor is paying us and took on no liability from Trinity Bay, as far as they've said. So
Yeah, but they're the lessee.
this is just with Trinity Bay.
Okay, get yourself a lawyer. I mean, I think Endeavor as the lessee is liable for royalties owed under the lease, regardless of whether they agreed with
Right.
Trinity Bay or not.
Okay. I know Endeavor is also owed the same time period from Trinity Bay. But
I'm saying you can collect the amount from Endeavor.
oh, okay. Did not know that.
Okay. And appreciate providing that advice. I do think it is sort of outside of.
Well, I mean, you know, we're going to enter an order, I guess, against Trinity Bay because that's the only relief sought, but
Yeah.
the
They can
relief-
proceed
relief
to-
could have been expanded. If they're not getting paid, they should go after the operator.
I think we just need to vote on what's in front of us.
I agree.
So if they want to get an attorney on their own, they can.
Okay. Are we ready? No further discussion. We'll entertain a motion.
Oh, so moved.
Okay, go ahead.
We still need a motion, actually. And I think that motion, if whoever's interested in making that motion should be for payment, an order directing Trinity Bay to make payment to the applicants in the amount that's set forth on base page 00031 as for each of the applicants, but, so you'll need to look at that.
I was going to offer to do that.
Okay, please go ahead.
Go for it. Are
So
you going to do it?
So you may do it.
I move what you just said.
So the motion, if we can read that, is an order to award payment of proceeds and interest due from Trinity Bay Oil and Gas, which is operator number 10367 Trinity, or the payer for production attributable to the mentioned well located in Kiowa County, Colorado, and award relief for all associated costs and attorney's fees. Undertaken to do that to Janet Shield, Linda Tallman, and Marlis Hindus. Okay, as the pays of the applicant, fees attributable to the payment due from Trinity as set forth in Bates exhibit, Bates 30 and 31. That is the motion that's in front of us today.
Second.
Seconded by Commissioner Wall, motion made by Howard Boygan, and just restated by Chairman. Any further discussion? We ready to vote? All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries.
Thank you.
Thank you.
You're very welcome. Good luck.
Thank you.
I
Being here
agree
so
with
late.
Commissioner Boygan. Go find a lawyer.
And I want to say I applaud your diligence in doing this.
Yeah.
Yes.
Sorry you had to drag yourself down here and go through all this, but hopefully you'll get
Had to
some.
get that ruling. It's for the principle of it.
Yep.
Thank you.
Ms. Bryan, what is next on our agenda?
Mr. Chair, next on the agenda is a short presentation from Great Western Operating Company regarding the Dittmer location.
I think the operative word here is short.
Well, we will keep this brief, and my name is Jeremy Conger. I'm with Great Western Operating Company. I'm the Senior VP of Operations. We're here at the request of Director Lepore to explain, two incidents that happened on the same location within a month of each other. We do have some slides. Are they going to be able to be put on the screen, or?
Yep.
Sure, where they're at, sorry.
So while we're doing that, we'll keep moving.
Great Western, Dittmer
we're going to be going over where this pad is approximately. The two incidents, one occurred on September 20th and one occurred on October 12th. We're going to be going over what caused these and then the corrective actions and precautionary measures that we've taken to ensure that nothing like this happens again on any Great Western facility.
We know where the hearing is, the material there.
He is looking for it. We emailed them to do, sorry, this is Ana Gutierrez with Hogan Levels on behalf of Great Western, and we're just looking to pull up the slide deck.
So this was on the agenda for tomorrow morning. Maybe it's in a tomorrow folder.
Originally.
Yeah. So I think
While
we
we're
can.
looking for that, perhaps, Ms. Prine, should we address the remaining consent agenda items? We're waiting.
Yes, Mr. Chair, the remaining items on your agenda are the 8 new consent agenda items, as well as approval of the October minutes with the added language that Commissioner Boygan requested.
Okay, so let's address the October minutes. Can you read the added language?
I can. I'm also sending around a red line version. The paragraph in question now says commissioners spoke in depth about their concerns about entering spacing orders that address surface matters. Commissioner Randall proposed language to modify the proposed order as it related to the memorandum of understanding between the city and county of Broomfield and Extraction Oil and Gas, Inc. After some minor modifications made through commission collaboration, the following second version of the proposed order was considered and approved by the commission.
Okay, so I think we can add oil extraction and the word oil.
Yes, I got that.
Oil and gas. With that correction,
it's going to be a problem, but we're changing them, where we actually have changed them all out. There were 111 of them that we've changed out, and that work is complete. So now I'll turn it over to Scott Donato to just go over a few more things.
Thank you. So on October 18th, 19th, 20th, and 24th, after the second incident, we conducted hydro tests on all of our separators in conjunction with the Oil and Gas Commission personnel out there and the related flow lines to the maximum allowable operating pressure, or MOAP, for a minimum of 30 minutes, which is longer than typical that we've done on that type of equipment. We also conducted a continuous production watch of the Dittmer facility during startup. So that was 24 hours a day with personnel on site, conducting both AVO, audio, visual, olfactory, which is what we do for the health department for emissions leaks, as well as had a 4-gas monitor that detects methane, of course, as well on site. In addition, we did a FLIR camera inspection of the facility after each well was turned on. We turned on 2 wells at a time at the direction of the commission every 12 hours and monitored those for those 12 hours. And then we've been doing it weekly ever since to date. Our requirement at that facility is to do monthly FLIR testing anyways, but we just increased it to weekly just because of the incidents and wanted to make sure we didn't have any issues out there. Next slide. We developed a new standard operating procedure for installation of those anodes, utilizing that groove lock coupling and sealing system that you saw the pictures of. Again, they're only now in our low pressure heater treaters and free water knockouts, none of our high pressure equipment. We updated our audio visual and olfactory training for our personnel. We updated our pressure testing for the standard operating procedure for the pressure testing. And then in addition to this presentation, at the behest of the commission, we presented this information through COGA to 3 safety groups that we're members of: the DJ Operators Consortium, the DJ Basin Safety Council, and the Front Range Emergency Response Co-op, just so that even though there was notification out there by the commission, we wanted to go to those groups specifically where safety members attend and make sure they understood what we went through. So it was the notice that the commission had put out and explaining to all the different operators in case they had the same equipment. And with that, hopefully that was fast enough, but we're happy to entertain questions.
Just one question on the ones that when you presented that to other operators, how many of them are going to go replace their Victaulic couplings?
Tell me if I get this wrong, but we only know of one operator that had this same coupling on a high pressure separator, and we notified them, and we believe that they took that out of service, but can't speak to that.
Okay, thank you.
So that leads to Mr. Chair, sorry.
All right, Commissioner Boygan.
That leads to the obvious question: why were we the only ones who were doing it and nobody else was? Was there like a root cause analysis of this done?
So we had 2 different brands of high pressure separators on this site. One was manufactured by PSE, and the one that we had issues with was manufactured by Dragon. It was a brand new design out there. So as far as we know, we were some of the first people to try it, along with one other operator had one in service. So fortunately, it was very early in the life cycle of this product, and this issue arose. And we have communicated, extensively with the manufacturer about, the issues we found.
And Commissioner Boygan, we've done a full root cause analysis, and the report will be presented to the Oil and Gas Commission as well as to OSHA, who was on site as well.
Right, good, thanks. So I'm just wondering, what's the larger lesson, if any, that you can draw from this? Don't try new stuff?
Don't use Victaulic couplings on high pressure stuff.
High pressure equipment, absolutely, yeah. Unfortunately, there were several issues. One is there are really no specifications out there for the old, redhead anodes. A blue one is just for a different size pipe, but it's otherwise the same material. So there's red and blue ones you'll see out in the field. They're a resin plastic thing, and the best we've been able to get out of any of the people that sell these things today is, well, I probably wouldn't use it over 100 PSI. Okay, well, the clamp and gasket were provided by the manufacturer. So, from my perspective, we researched that now. We went and found gaskets and clamps that, we certify to be compatible with our equipment, as well as having a steel-headed anode that was actually modified from its standard version to have a thicker lip on it so that we can reduce that pipe in gap and keep it within the specification of all the pieces of the system.
All right. Thank you very much.
Well, we appreciate your time.
Mr. Chairman?
Yes.
If I may, I'd like to give a real quick chronology from the agency's point of view.
Certainly.
And also I want to thank Great Western for their presentation. But September 20th, fire number 1, all of the wells on that location were back in service by September 25th. And then October 12th, the second fire, same location, same type of fire. That's 22 days later. Obviously, in the wake of the fire, Great Western had shut that location in. We had folks on site. On October 16th, which was the Monday, we issued a cease and desist order to Great Western. That is authority that I have. I think it's the 3rd cease and desist order I've issued in 5.5 years. So we don't use it except in sort of extraordinary circumstances. The following day, we asked Great Western to provide us a great deal of information about the incident. They did that in a timely fashion, and again, we appreciate that. It was a very thorough response to a long list of questions. On October 19th, we put a notice on our webpage about these anodes to notify the regulated community that we had identified at this point, still sort of a hypothesis, but a pretty good working hypothesis of the cause of those 2 fires. So we were trying to get that information out to the regulated community. We got the response to the request for information on October 27th. There was a little bit of back and forth between Great Western and our flow line integrity group. And we withdrew the cease and desist on November 3rd after participating in and watching Great Westerns go through the process of bringing those wells kind of back online and so forth, right? Pressure testing and all that. So just wanted you to be aware, there was a recent news article about fires, et cetera. We're not oblivious to those, and this was sort of the agency's response to this one in particular. So.
Good job. Thank you. Good job. Thank you both. Ms. Prine?
Mr. Chair, the only remaining issue on your agenda are the 8 new consent agenda items. 171-000-723, 724, 725, 726, all Nickel Road. 171-200-887 and 888, both Great Western. 171-200-862, Crestone Peak, and 170900562, which is the BBC matter that was on your agenda for hearing, but was settled towards the end of our process.
So in terms of documentation, we have the BBC matter. The others, is it possible to beg the commissioners, if we could obtain a summary of what these other hearing matters are, could we vote on those? Since they would be normally consent agenda items. I believe we'll actually see documentation on that out tomorrow on the specific orders.
Yes. Hearing Supervisor Rouse has brief summaries for you, and I can provide by email all of the backup documentation by tomorrow.
Is that acceptable to the commissioners? I'm seeing heads go up and down, yes. And Mr. Rouse, if you'd like to summarize for us.
All right, we have 1710-00723 and 1710-00724. Wattenberg Field, Codell and Niobrara formations, application filed by Nickel Road to establish a 320-acre drilling and spacing unit for the Codell and Niobrara and to pool that unit also. There was a protest by John Hall, which was withdrawn this past Thursday or Friday. There is sufficient evidence to support the spacing and pooling applications. 1710-00725 and 1710-00726. This is a Nickel Road application to space a 1,280 acre drilling and spacing unit for the Codell and Niobrara formation in the Wattenberg field, and then the 2.6 case is to pool that drilling and spacing unit. There was a protest by Extraction because of a conflicting drilling and spacing unit. That protest has been withdrawn, and there is sufficient evidence to support the spacing and pooling applications. Docket number 1712-00862 is a Crestone Peak spacing, 640 acre drilling and spacing unit for the Codell and Niobrara formation in the Wattenberg field. There is sufficient evidence to support the application. And then we have 1712-00887 and 1712-00888. This is a Great Western spacing and pooling applications to modify prior orders to add the Greenhorn formation for an existing 1,120 acre drilling and spacing unit that had previously been established for the Codell and Niobrara. So they are amending the prior.
I'm sorry, drilling plans. They needed the capital deployment to confirm their drilling plans for early 2018. From the Great Western standpoint, they do have a rig on location. And I guess I want to make a point to this, something that was said earlier by Ms. Shepard and then discussed by the commission. The reason we're here is not because of reasons that they just didn't get on. They are real reasons as to affecting the either capital deployment, drilling obligations, drilling commitments, rig schedules, as well as finalizing a drilling schedule for January of 2018 and with respect to Crestone. With respect to BBCs, that's up here. That was actually set for hearing in October. That was continued because of the extraction Crestone matter that went very late into the evening. That was set for November. Then that got continued because Verdad's counsel said that he had a family matter come up and he was not going to be able to be here. So BBC voluntarily continued that on that basis. Then as we proceed to hearing in December at 5 o'clock on Friday, Verdad, with no reason, withdrew its protest. And so, you know, BBC should not be penalized by putting this to January. So those are the reasons we're up here. I mean, we are very cognizant about coming up here today and asking you for these. We found out about this basically Saturday morning. For all of the matters I'm up here talking to you about, we received no email from staff stating that they would be continued or even not on the consent agenda. And so that goes to the point earlier where if this is going to occur, there does need to be some communication at least so we can inform our clients as to what is going on. One of the other things I guess I want to make clear is that when there was the statement of operators need to come to the state with priority, these operators did. Great Western did. Great Western actually voluntarily continued 3 of its other matters so it could have the 2 you're hearing right now up today. Same with Nickel Road. It continued another matter. And then Crestone had several continued as well. So we're working with the staff. I just want to make it very clear that the reasons they're up here today are very significant reasons, as you heard this morning from not only Andrew Haney, but also Hal Ryder from Great Western. Thank you.
Thank you. That was very helpful.
Okay.
Can I respond though?
Yes, Commissioner Boygan, yes.
They're each sui generis. I mean, settlement, the Verdad BBC thing, to me, that's completely understandable, and I agree with that wholeheartedly. But I have a problem in concept or in principle with the notion that anybody, you or anybody else, and we have implicit trust in you and you have great credibility and we take you at face value. Anybody can sit there and say, well, I've got a client that's got a capital commitment. We just got to have this thing today and it's really going to cause us a lot of problems. We have no way of verifying that, or there's no standard. It's like everybody's got problems. Everybody's got pressures on them. Why do we make an exception? Or in what circumstances should we make an exception? So I'm just saying, as a general matter, I don't think this is a procedure that we should follow. At the same time, I agree that we need better communication.
And Mr. or Commissioner Boyden, thank you very much for saying that. We were ready to present. So this wasn't just going to be myself and Kelsey up here presenting. We had all of our witnesses for all of these matters here earlier today. We were informed that the witnesses would not be needed. So we submitted, and I actually don't know where they went, because we worked very diligently yesterday to prepare for exactly this. In the packets that I prepared today that I gave to Ms. Prine, you had the application, the affidavit of mailing, notice of hearing, certificate of service, publication, 511 testimony, all exhibits, and draft order to be put in front of you today for all of these matters. I also had every single witness here because, again, we don't take this very lightly. We very much understand this is an exception and is not the rule. So I just want to make it clear from our perspective that we understand. And these are very unique circumstances that actually did come up with the applications in front of you today. Is this not something I'm going to be running out telling other clients that they can do?
So the difference being is that you discovered they were not on the agenda. And
On
that's why
Saturday morning.
On Saturday morning, they
Yes.
were not on the agenda.
Yes.
Okay, all right.
Thank you.
Okay, yes, Commissioner Wall.
Thank you, Mr. Chair. So Mr. Rouse, it's your recommendation that we consider these 8 items on the consent agenda?
Yes, it is.
Then I move approval.
Second.
Okay, it's been moved by Commissioner Walk, seconded by Commissioner Holton, that we approve these remaining 8 items that were essentially added to the consent agenda. Any discussion? Hearing none, are we ready to vote? All in favor, please signify by saying aye.
Aye.
Opposed, same sign. Motion carries. The items are approved.
Great. Thank you very much for your time and consideration of these. Thank you, Mr. House.
Commissioners, thank you for a very long day. And
Thank you for getting the schedule shortened for one day.
I will, the thanks go to Ms. Prine and to the director and the staff for making that happen. Yes.
Can I just thank Commissioner Jolly for the popcorn balls? This might
Hey, you're all
actually be
welcome.
dinner for the
Thank you
night.
very
so
much.
I appreciate it.
Dinner.
Thank you. Thank you very much.
My pleasure.
All right. So I think we do need to move to adjourn.
Second.
Moved by Commissioner Randall, second by Commissioner Walk. All in favor, say aye. Aye. We are adjourned. We will see you in January for rulemaking, which will be a new experience for some of the commissioners. I hardly wait, yes.